Mr. Bursch, you ready?
Thank you, Your Honors. Good morning, and may it please the Court. My name is Caleb Grant, and I represent Mr. Andre Green. In 2011, Mr. Green pled guilty to 2 crimes of violence as defined by Section 924C. Then, in 2015, the Supreme Court decided United States v. Johnson, which invalidated a similar residual clause in Section 924E. Mr. Green filed a 2255 motion within a year of that decision of Johnson, and while that case was on appeal before this court, the Supreme Court decided United States v. Davis.
What's the issue for us to decide here? Everybody agreeing on count 29?
Yes, Your Honor, the government has conceded both timeliness and infirmity for count 29, and it's our position that the motion was also timely as regards count 30, and that that conviction is also infirm.
What do we need to do today?
Your Honor, today we asked the court to find that the motion was timely and that the conviction is infirm. And so we asked the court to reverse the district court and invalidate Mr. Green's conviction.
The conviction is infirm based on what?
Count 30 is infirm based on 2 reasons, Your Honor. First, that the Hobbs Act robbery is categorically broader than the 924C definition of crime of violence. And second, that the elements clause has been used to replicate the work formerly done by the residual clause.
Okay, so is your argument based on the force clause or the residual clause?
Well, Your Honor, the challenge here is a Davis challenge to the residual clause. And if it were just a conviction under the residual clause, Davis would answer that question firmly in Mr. Green's favor. In order to get to that question, however, we have to examine whether Mr. Green could have been convicted under the elements clause. And it's our position that he could not.
Under the force clause?
The force clause, yes.
Did you raise the force clause below at all?
No, Your Honor, and this is simply a way of examining whether Mr. Green could have been convicted under the residual clause.
That's your argument for why it's not waived, because this is, even though you didn't mention force below, this is a way of examining?
Exactly, Your Honor. This is kind of the criminal law 1 way of looking at whether that conviction could have been under the elements clause, and if not, then it must have been under the residual clause. And Davis would answer that that conviction would be infirm for that reason. So to examine the elements clause, then, we have to look at whether Hobbs Act robbery is categorically broader than Section 924C. And it is for a very simple reason. After the decision in United States v. Taylor this last summer, the Supreme Court created a fairly bright line rule that laid out exactly how to analyze whether a predicate crime is a crime of violence. The Supreme Court said that in order to determine whether a predicate crime is a crime of violence, we have to look at whether on the 4 corners of the statutes, the government is required to prove the use, attempted use, or threatened use of force. And the question isn't whether the government sometimes has to prove those things, but whether it always has to prove those things. And here, Hobbs Act robbery can be committed by creating a fear of injury to intangible property. Intangible property, we know that that is part of the Hobbs Act robbery because of United States v. Mathis, a case out of this circuit, which found that there's no distinguishing between tangible and intangible property.
Where is this going? Are you saying that 924C is, the force clause is unconstitutionally vague itself?
That is one argument that we're making here today, Your Honor. But the broadness argument, the overbreadth argument, is simply that 924C requires the use of physical force. And Hobbs Act robbery can be committed by creating a fear of injury to intangible property, and physical force, kind of on a metaphysical level, cannot be used against intangible property. And therefore, Hobbs Act robbery is broader than 924C's crime of violence definition. And we recognize obviously the weight of the authority against us here, but just last week, a district court judge in the Southern District of Florida, ruling from the bench, in fact, did find that after Taylor, applying the new test laid out in Taylor and looking at the jury instructions for Hobbs Act robbery, that Hobbs Act robbery is broader than the 924C crime of violence definition, in particular because of this intangible property argument.
That court the only one to do that?
So far, yes, Your Honor. This is
district court out of Florida.
That's correct, the district court out of Florida. And obviously, again, we recognize that that's perhaps hopefully a persuasive ruling from that court. But the idea is that this tide is starting to change. After Taylor, the analysis
Tide is starting to change because of one district court in Florida?
Well, Your Honor, after Taylor, the analysis changed pretty drastically. And the Supreme Court in Taylor, really cut the analysis down to this bright line rule of, is the government always required to prove the use, attempted use, or threatened use of force? What courts did in the past was kind of add on these extra tests in order to get around these tricky arguments like the intangible property argument. In particular, the courts have used tests like the reasonable probability test, and other circuits have done that explicitly. This court has, cited to cases which do use that test, and they cited to those cases in Mathis. The court hasn't expressly addressed why it did not consider the intangible property argument to show that Hobbs Act robbery is broader than the 924C crime of violence definition. But the court cited to those two cases in Mathis, which relied on that reasonable probability test. And so it's reasonable to conclude that, to some extent at least, this court has used the reasonable probability test to get around this intangible property argument.
In Mathis, did we discuss reasonable probability?
Not explicitly, Your Honor. And again, this is where...
What do you mean not explicitly? Not at all?
Not at all, Your Honor. Not in the text. But again, citing to those cases, and the two citations are the only ones that even mention this intent.
But the two citations, the pinpoint sites that Mathis cites to, are not citing to the pages that discuss reasonable probability in those two cases. They're citing merely to the ultimate conclusion that it is a crime of violence.
Correct, Your Honor. And that conclusion was reached by applying the reasonable probability test.
You're saying that conclusion was reached in those other two cases,
Exactly.
not in Mathis?
Correct, Your Honor. But even if Mathis wasn't relying on this reasonable probability test, just because of the kind of, again, the metaphysical impossibility of using physical force against intangible property, Mathis must have been doing something beyond the straightforward test that the Supreme Court laid out in Taylor. In addition to that, and to get to Judge Wynn's question about the constitutionality here of the Elements Clause, we can look at United States versus Malacu. And in that case, basically what the court did was create these kind of two conceptual buckets. First was for pure property crimes, what it called pure property crimes. In that case, depredation against government property. And the court said that those were not categorically crimes of violence. But the problem is that that would mean that Hobbs Act robbery, if committed by injuring property, might not itself be categorically a crime of violence. And so the same judge that wrote Mathis and that wrote Malacu clarified that because Hobbs Act robbery was in this kind of second conceptual bucket, which involved the risk or use, the risk of bodily injury, then that made Hobbs Act robbery itself a crime of violence. The problem is that this collapses the distinction between the Elements Clause and the Residual Clause. In the Residual Clause, the test was whether there's a risk of use of force. And we know that from United States versus Stokeling that the risk of use of force is essentially that force must be violent force, and that is force capable of causing injury. And so the analysis with the Residual Clause is whether there's a risk, essentially, of injury. That's exactly the same analysis that the court applied in Malacu to determine that Hobbs Act robbery was a crime of violence, specifically that there's a risk of bodily injury because of the presence of two individuals. So, because those analyses are the same, what's happening is that the court is using that same analysis to replicate the work that had formerly been done by the Residual Clause, and because it's doing that, and that's something that the Supreme Court in Taylor specifically said not to do, that collapses that distinction and introduces the same kind of constitutional infirmity into the Elements Clause, and that's what Judge Diaz pointed out in his dissent in Malacu. Now, briefly to turn to timeliness, Your Honors, which is the other issue today. As we argued in our brief, several other circuits have found that these types of motions, which are premised on Davis but based on Johnson, are timely. In particular, we have Granda versus United States out of the 11th Circuit, Truby versus United States out of the 11th Circuit, and United States versus Vargas Soto out of the 5th.
Well, and in this circuit, the government's conceded that point in at least 4 separate cases, correct?
Correct, Your Honor. The reasoning from both the other circuits and from the government's concessions is persuasive as to why this motion should also be found timely. And while the government has not conceded timeliness here for count 30, in other cases, the government's concession of timeliness has gone so far as to say that Davis itself makes these kinds of claims timely. And that's in United States versus Williams out of this circuit in 2021.
So what does that mean in this case? You just said they didn't do it here, but they did it there, so what?
Well, Your Honor, the reasoning that they used there is the reasoning that we asked the court to adopt today.
You said they didn't do it here.
Correct, Your Honor. And
Is there any law of the case, or what is the value of the fact they did it in one case? I mean, if we follow that principle, there are a lot of things the government, or perhaps defendants do, but certainly the government do. For one case, they don't do it in another case. I'm just trying to understand the legal basis, other than they gave a good reason for doing it was all there, but it wasn't done here. So what?
well, Your Honor, it's a good reason, as you point out, right? And
No, hold on a minute. What do you mean it's a good reason, as I point out? I didn't point out a good reason. I asked a question. Why is that making a difference in this case?
Well, Your Honor, the motion here was timely, and it was timely because while Davis came out in later than Johnson, what happened was that Mr. Green filed his 2255 motion within a year of Johnson, and Davis extended Johnson to the 924C statute, which Mr. Green was convicted under. And so because Davis extended that finding in Johnson, effectively what would be happening is that the court would be penalizing Mr. Green for filing his motion too early. He filed it within a year of the case. I mean, Johnson was I've seen it described as a bolt from the blue. It really did undermine, almost unanimous precedent in the lower courts and a Supreme Court decision, all of which had upheld the residual clause and the validity of the residual clause. And so Mr. Green filing within a year of Johnson is enough to show cause, and we can look at the Reed versus Ross kind of test here for overcoming procedural default. It's enough to show cause because of that unanimity of lower court precedent and the Supreme Court decision, and Johnson overturned that. And so by filing within a year of Johnson, Mr. Green was properly raising a challenge that he could not have raised realistically before Johnson. And the two counts that he pled guilty to were the two most serious counts of his indictment, and therefore he also is able to show prejudice under that standard. And so the court should find, therefore, that his motion was timely for that reason. And then finally, the Section 2255 statute discusses the timeliness of the motion itself and not the timeliness as regards each individual claim. And so by conceding that the motion was timely as regards count 29, it's our position that the court should also find that the motion was timely as regards count 30. And that's, this is simply because, these are both based on the same set of facts. These aren't two completely different claims, completely different charges. They're both from the same indictment, same set of facts. And so being timely for one should be timely for the other. We respectfully, therefore, ask this court to reverse the district court and invalidate Mr. Green's convictions. Thank you.
Thank you, Mr. Birch. Mr. Atias?
Thank you, Judge Gregory, and good morning. The defendant's challenge to count 34 is barred by numerous procedural obstacles, any one of which is sufficient for the court to dismiss his challenge. The first, and we sort of have to start here because we are, after all, on appeal, it's just a straight-up issue of preservation. The two key challenges the defendant raises here, the only two that really matter, the challenge to the Hobbs Act robbery and the challenge to the Elements Clause, neither of those claims are even remotely presented below. So they weren't raised below, so they're not properly before this court. The second reason why the defendant's challenge is procedurally barred is just a matter of procedural default. We spent 5 or 6 pages addressing the issue of procedural default in our brief. The defendant hasn't responded to a word of it. I heard a bit of it today, a bit of a response today. But there's no question that the defendant's challenge is defaulted. The only question is whether the defendant can show cause. And we've included in our brief numerous cases defendants have been challenging.
So you're arguing that that it's not timely as to count 34, correct? Well, what
Sure.
is different in this case versus Williams, Brantley, Woodley, and McClammy, where the government said that those were timely based on Davis?
Sure. So there are a few key differences. In all four of those cases, the defendants actually moved within a year of Johnson and challenged below the validity of their 924C convictions. They based their challenge on Johnson. They attacked the residual clause.
Okay, and the appellant here based the challenge on Johnson. The district court acknowledged as much in denying it.
Well, there's a factual difference between those four cases and this case. In those four cases, the defendants actually challenged their convictions. They raised the challenge to their 924C convictions based on Johnson. They also included a challenge under the elements clause, sort of a two-step challenge. And the defendant here did not do that. He raised
Were the four of them pro se?
I believe one of them was pro se. I think he was pro se initially, and then at some point, maybe for response, he got counsel. The key difference is that those defendants did actually assert the right under Johnson that then Davis later endorsed. And so this does get a little metaphysical, but if you're actually seeking to assert the right under Johnson, you're just calling it by a different name because Davis didn't exist. You're seeking to invalidate the residual clause, but you're doing it under Johnson. Your appeal is still pending. Davis comes out. Well, then Davis has endorsed that right, effectively rendering it timely. And that's the theory, as I understand it, that informs the government's waiver. And it's also the theory that the 11th Circuit in Granda reached on the issue of timeliness. But that's not this defendant. Another reason why this case is different is that in all four of those cases, there was actually an underlying merits claim, an actual challenge to the predicate offense that each district court skipped over because they had just dismissed on timeliness grounds. And so this court remanded for the court to actually address the challenge that it never got to address because it had just dismissed on timeliness. But of course, if that happened here, there's no underlying challenge to a predicate that's just sitting for Judge Smith to address. There's nothing in that motion. Another key distinguishing factor between this case and those cases is that those defendants actually all asked for a remand so that they could pursue either their challenge to a predicate offense or develop the record as to there were some issues that had to read an indictment or a plea agreement.
Counsel, aren't those distinctions without a difference? The key is that what the Supreme Court in Davis retroactively said these issues deserve to be reviewed. And counsel, defendant or the appellant here did what he could do. He challenged under Johnson, then existed. It's like you can't have it both ways. Sometimes the government said, well, you should have anticipated what the law was going to be, and therefore and you're barred because you didn't anticipate. Here's just the opposite. You're punishing him, as counsel said, because he was too early. Because he's clairvoyant, because he has visionary about what justice might look like later with the Supreme Court, and the Supreme Court actually did it. And you're saying that it's different. There are distinctions, but they're really no different. It's before us. It's timely in terms of address the issues that Davis said would retroactively, right? Isn't that right?
Perhaps if we actually had a real Davis challenge here, a challenge that actually relied on, for example, the defendant in Sims. Had Davis existed, Davis would have resolved the whole case because he only had a conspiracy predicate. But we've waived our procedural offenses to count 29. What we have here are two elements clause challenges. We couldn't possibly waive timeliness on those issues because the defendant is seeking to assert a right that doesn't exist. In fact, a right that literally no court has ever recognized, a court of appeals at least, let alone the Supreme Court. That is a challenge to the elements clause. That's a brand new challenge. And then the challenge to the status of the Hobbs Act robbery. So we can't really waive timeliness to the two claims that matter. Those are the rights the defendant is seeking to assert because they can't be found in any case law from the Supreme Court. But as to Your Honor's point about clairvoyancy, the reason why we included, and this is more of an answer, more of a procedural default issue, than a timeliness issue, but I see how they overlap. We've included in our brief numerous examples of defendants as far back as the 90s, but certainly in 2016, challenging the status of Hobbs Act robbery as a predicate. I mean, that was literally all the rage after Johnson. There are scores of defendants who are doing that in just the Eastern District of Virginia. If there weren't word limitations, we would have included many more examples in our brief. And of course, there were cases pending before this court in Hare and Ali. These are all around the same time in 2016. The defendant in Mathis, also 2016. The defendant in Sims, also 2016. Everybody was making these challenges. So I don't think it's fair to say that there was anything novel about challenging the status of your predicate offense. We have examples from Leocal, for example, in 2004, 2006. The Supreme Court is addressing elements clauses, residual clauses. And this court in Fuertes in 2015, before Johnson, had already struck a predicate under both clauses and before Johnson. So it's not really fair to say that we needed Johnson or even Davis to make what is really a garden variety elements clause challenge.
What if you attempted to file a Davis-based 2255 motion now? Would that be time barred?
I think, we're obviously more than a year after Davis, but the question is, well, what would he be asserting? If he's asserting these two claims, tomorrow, the two claims that matter in this case, well, they'd be untimely or sort of premature because he couldn't satisfy 2255F3. But the reason why we waived as to Taylor, in a way, it benefits the defendant because depending on what happens in this case, it spares him from having to file a successive petition based on Taylor, is because he deserves relief under Taylor, and so that conviction is infirm. But as to the two challenges here, the Hobbs Act robbery challenge and the elements clause challenge, I don't think it would be timely because he couldn't satisfy F3.
When would it be timely?
Well, the Supreme Court would have to recognize a right to be free of unconstitutional elements clauses. That's their theory, and that's the right that they're seeking to assert. The same way the Supreme Court in Davis recognized the right to be free of unconstitutionally vague residual clauses.
But isn't that really the merits of it? I mean, that may or may not be the case after we look at the merits, but timeliness is a different question, isn't it? I mean, it's the only temporal venue he would have to address it. And what you're raising, in the merits, that you may or may not be correct. But timeliness is something different. That's categorically saying, because Davis opened it up for him to look at and for a merits question. So it's not just because it's opened up, it's automatically they win. I mean, you suggest that because you may have defenses and might win, but that's not dispositive of whether or not it's timely.
I think it is. I think this.
Oh, you think it is?
I think it is. I think this court's decision in Brown makes clear that the Supreme Court hasn't formally recognized the right that they are trying to assert now is not the right to be free of a residual clause. We all agree that that clause is out. Right. The right that they're trying to assert is the right to be free of an allegedly unconstitutional elements clause. And there's no case that establishes that proposition, not even close. And so there is an element, an aspect of timeliness that bleeds into merits. And I think Brown recognizes that. Other circuits disagree to some extent.
Well, what happened to the old rule of lenity? You just admitted that there's some leaching into it, but you said that we should decide that it's not timely. I mean, isn't the rule of lenity designed to do that when there is some ambiguity and some question? It always inured to the benefit of the defendant. I mean, that used to be the criminal. When I was in law school, we taught it. I know it's hard to find it now, but isn't that the case?
I don't think that's the case. I mean, lenity.
No, it's not the case in existing now, but there is a rule of lenity, isn't
There's definitely a rule of lenity, and it applies to statutes when courts have tried everything.
Yeah, but that's the whole problem, isn't it? We're trying to get this thing straight. People were getting these draconian sentences increased because of predicate offenses, and now we know that they were infirmed. They're infirm, and Davis said so in those cases. Isn't that why we look now at it, when we have a chance to look back at it?
I don't think the defendant's sentence is draconian. He murdered two people.
It's not.
So that's just first and foremost.
First and foremost, I was talking generally about draconian sentences, so don't take it out of context what I said. I said in general, these predicate offenses were used to increase sentences that led to some draconian sentences. I didn't say this particular one, counsel.
I don't think
And even
lenity.
with that, that's your view, but I understand it, but I didn't say that.
Okay, then I misunderstood. I apologize.
You did.
Your original question was, does lenity apply here? And my answer is no, lenity doesn't apply here because we're not construing a statute that's ambiguous. This court has binding precedent on what it means for the Supreme Court to assert, to recognize a right under F3, and lenity doesn't really play a role in that respect. So I've gone through my three big ticket reasons why the defendant's ultimate merits claim is procedurally barred. Final reason, even if the court gets to the merits, is this court's decision in Mathis. This court has held that Hobbs Act robbery is a crime of violence. It's already addressed the intangible property theory of liability under the Hobbs Act, which we don't believe is actually a theory of liability, and this court can affirm for that reason alone. If the court has no other questions, I'd be happy to address any, but if not, happy to sit down.
Are you going to respond to counsel's argument about as to applying to tangible, intangible arguments?
Sure. We don't think that you can commit Hobbs Act robbery by threatening intangible property. This court in Mathis has already dealt with that issue. Every court of appeals that has passed on it has also rejected it under dueling theories. That's binding on this panel, and if the defendant wants to make further arguments, you can certainly do so in an en banc petition, but as far as this appeal, for present purposes, Mathis controls that question. If the court
What does
has,
Mathis mean when it says that the Hobbs Act robbery or 924C draws in a distinction between tangible and intangible property? That acknowledge that the robbery can be committed against intangible property?
I don't think so. So I think the best way.
What does that mean then? What does
Sure.
that mean when it says that? It says neither of those, neither this Hobbs Act robbery nor the 924C draws in a distinction between tangible and intangible property.
Yeah, so I think the best way to read that is that the two clauses are very, very similar. And so whatever you say about one clause is likely going to be the same about the other clause. So what we say about robbery, what it means to commit robbery is going to be the same as what we say would satisfy the force clause. And I think the reason why that's the best reading of that passage is because the paragraph above addresses the defendant's fear of injury argument under McNeil. And it says that to satisfy that prong of the statute, the last of the three ways in the Hobbs Act robbery statute, is that it requires, for fear of injury, it requires physical force, and that's physical violent force. So it would be odd if the first paragraph said, you can't commit Hobbs Act robbery without violent physical force, and then the next paragraph said, actually, you can commit Hobbs Act robbery by threatening force against intangible property, which you can't do. So that's why I think that paragraph is best read, that passage is best read that way. And of course, even if Mathis did acknowledge that you could commit Hobbs Act robbery by threatening intangible property, and we don't think it did, and even if that was dead wrong, that would still be binding on this panel, absent en banc consideration. But we don't think that's what it means, because we don't think that you can commit Hobbs Act robbery by threatening violent force against intangible property. If the court has no other questions, we'd ask that this court affirm.
Thank you, Mr. Tiers. Mr. Birch, you have some time reserved.
Thank you, Your Honor. A few points on rebuttal here. First, as to the procedural default issue, Mr. Green had signed an appeal waiver after his initial guilty plea and had no reason really to appeal his conviction at all because of that until Johnson came along. Johnson wasn't there after his initial conviction, and so appealing that sentence right away would have been barred not only by the lower court precedent and the nearly unanimous wall of law there, but also by Supreme Court decisions upholding the residual clause. And the district court really did recognize what his claim was as a Johnson claim. The district court and Judge Smith knew what to address in that order. It was the only thing that could have been addressed. And again, this comes back, Judge Gregory, to this very kind of elementary criminal law way of looking at the application of a statute. You know, you can look at whether the statute itself applies to the conduct. You can look at whether the statute is vague. And those are kind of the basic ways of approaching whether a statute applies and whether a conviction is infirm. And so that, you know, this doesn't go beyond kind of what the judge understood in the lower court and what the judge addressed in that lower court order. And while the appeal was live here, while Mr. Green's appeal was before this court, the court issued a certificate of appealability that specifically referenced the fact that his claim was premised on Davis. And so he would have had no reason to refile a motion after Davis, because this court had already acknowledged that it was willing to address those Davis-based claims, which essentially did arise out of Johnson, and he had filed that motion within a year of Johnson.
If we find that the motion was timely as to count 34, are you asking us to consider the merits or send it back to the district court?
Your Honor, while this court can certainly send back to the district court if it feels appropriate, we believe that this is a question of law that can easily be resolved before this court, and that sending it back to the district court would be an inefficient way of using the court's resources. So again, while you know that's entirely within this court's purview, it would be best to resolve this question of law here. And then next, essentially his claim really does stem from Davis, and my friend across the aisle here suggested that this is an attack on the Elements Clause and that there's assertion of a right to be free from the unconstitutional Elements Clause. But the reality is that he is attacking his conviction under Davis and the idea that he was convicted under the residual clause and only could have been convicted under the residual clause. That's the challenge. And if that were if it was an obvious case that that was what happened here, that it was obvious that the residual clause was what he was convicted under, then Davis would resolve that question in our favor. That would be an easy case. This is a hard case because we have to look at the Elements Clause itself. We have to look at whether the Elements Clause could have applied, but it doesn't. And because the Elements Clause doesn't apply, we know that he must have been convicted under the residual clause. And because he must have been convicted under the residual clause, Davis tells us that that conviction is infirm. Next, we can know that Hobbs Act robbery itself can be committed by creating a fear of injury to intangible property. We know that from Mathis, which said there's no distinguishing between tangible and intangible property for the purposes of defining a crime of violence. That's the language from Mathis. And we know that from looking at the pattern jury instructions and jury instructions that have been used in this circuit. While it's true that not all jury instructions specifically reference economic harm, many jury instructions do. And we can look at jury instructions from the Fifth Circuit, the 11th Circuit, federal jury instructions, all of which define Hobbs Act robbery and Hobbs Act extortion separately, and in the Hobbs Act robbery instruction specifically include the idea that one can commit a Hobbs Act robbery by creating a fear of injury to intangible property, economic interests, things of that nature. So it's entirely possible to commit Hobbs Act robbery by threatening intangible property. And then finally, there is in Mathis a discussion of the intimidation, and my friend across the aisle here raised that discussion of intimidation and the fear of injury, but that raises the same problems that were raised in Malaku and the same problems of analyzing the risk of bodily harm in the Elements Clause and replicating the work that had been done by the Residual Clause. Thank you.
Thank you, Mr. Birch. Mr. Birch, I note that you are court appointed, and I want to, on behalf of the court, thank you. Depending upon lawyers like yourself who take on these cases to help us meander through these thorny issues. And also you have another assignment too, to introduce some special person to us today who's a student.
That's me, Your Honor.
Yeah, Your Honor, this is Caleb Grant, and this is Sarah Grace McCord, who helped me on the briefs in this case, and thank you very much for giving us a chance.
Right. And what school?
University of Georgia.
University of Georgia. Well,
National champions.
Go Dogs.
well, it's Judge Thacker would mention that.
Sorry,
But you're so good that I'm a Michigan grad, but I'm glad that we weren't there to get the results that happened in the finals. But thank you so much. You did a great job, and we appreciate students coming here. And again, thank you so much. And also, of course, Mr. Tiers, thank you for your able representation of the United States. With that, we'll go to our next case. Thank you so much.
Thank you.
Judge Gregory. And may it please the court. My name is Derek Teeney, and I am arguing on behalf of the petitioners on this petition for review. In December 2021, the Virginia Department of Environmental Quality and the State Water Control Board issued a water quality certification pursuant to Section 401 of the Federal Water Pollution Control Act for Mountain Valley Pipeline's water crossings here in Virginia. This petition for review should be granted and the certification should be vacated because the agencies refused outright to evaluate whether there were preferable locations for MVP's crossings. They uncritically accepted MVP's proposed crossing methods, and they inadequately addressed the threat to Virginia's narrative standards. But I want to start this morning with the jurisdictional question the agencies raise. The agencies contend that this court lacks jurisdiction because petitioners raised the wrong kinds of questions. But the agencies are wrong both about the scope of this court's jurisdiction and the nature of petitioners' claims. We agree with the state on one point, that in most circumstances, review of Section 401 certifications occurs in state court. But that is not true for 401 certifications for facilities regulated by the Natural Gas Act. For those facilities, like this pipeline, Congress wanted to bypass state court review and therefore prescribed expedited review of state 401 certifications in the federal circuit courts. Section 717RD of the Natural Gas Act gives circuit courts original and exclusive jurisdiction to review orders by state agencies acting pursuant to federal law for natural gas facilities. And as the Third Circuit has observed in the first of the Delaware Riverkeeper cases, that's 833 F3D at 371, a water quality certification cannot exist without federal law. Here, this certification on its face declares that it was issued pursuant to Section 401 of the Clean Water Act. That's at JA 0001. So Virginia issued the certification pursuant to federal law, giving this court jurisdiction under the Natural Gas Act. And this court's jurisdiction under that statute is broad enough or capacious enough, using the words of the Third Circuit, to encompass questions of whether an agency complied with the state provisions that govern its Section 401 program. The statute provides original and exclusive jurisdiction. There is no opportunity to split claims then between federal and state courts under that language.
Okay, so getting beyond jurisdiction, since your argument is that we're here pursuant to federal law, what is your best argument that the state of Virginia has authority to alter the FERC siting decision, which was based on federal law?
Certainly. So the Virginia program requires an alternatives analysis, and this court has recognized that such an alternatives analysis flows from the Clean Water Act, because the Clean Water Act is replete with such requirements, such as in the 404B1 guidelines, and that's the Mountain Valley Pipeline versus North Carolina Department of Environmental Quality case. So the Virginia program requires this alternatives analysis. One of the questions they have to ask is whether there are better sites, and so therefore they were required to evaluate that. To avoid that evaluation, they cite two statutes. I'm sorry?
The whole business of Virginia courts require this. I mean, it's express law that says the agencies are forbidden from altering the sitting determinations. So, I mean, how do you get around that? I mean, it's right there. So to say they require it seems to go in the face of something the statute says otherwise.
Well, those two statutes on which they rely, 21D2 and 81F, don't apply in this situation. 81.
Is this pipeline greater than 36 inches?
It is.
Then how does 21D2 not apply?
21D2 provides that that the state cannot alter a siting decision for, quote, such facilities, which begs the question.
Such facilities being the gas transmission pipeline that is greater than 36 inches.
Respectfully.
I mean, how are you reading this otherwise? I can't understand it.
Certainly. The such facilities are, pardon me, I want to ground myself in the statute. So that brings us back to the beginning of Section 21D2. Such facilities, refer back, okay, what kind of facilities? We start at the beginning right after number 2. Facilities and activities of the public service companies regulated by FERC or the state, except for construction of pipelines that are greater than 36 inches. The such facilities includes facilities except for. So an exception clause like that is an essential part of the definition of a class to which such refers. It's not the type of natural break. Under the last antecedent doctrine, when you look for what such facilities is referring to, you have to look to the entirety of it. It's facilities regulated by FERC except for these large pipelines. So that's why the statute doesn't apply.
That point is very key, is what such facilities are. Do you have any legislative history to support this?
The legislative history.
One from the angle that perhaps there is some ambiguity here. And your law seems to indicate that when the plain text doesn't indicate, you can look at the intent of the legislature. Do you have any such history here?
I think that if you look at the intent of the legislature, this change, this exception for 36-inch pipelines came up from Senate Bill 950 in 2018. And the entire point of Senate Bill 950 was to increase scrutiny of pipelines greater than 36 inches. The Virginia General Assembly had recognized that its permitting program had generally worked to protect waters, but it was worried about these large pipelines. So it's perfectly consistent with legislative intent for them to carve 36-inch and greater pipelines out from this site alteration provision. So to the extent that we need to look to legislative history, that informs what it means. But the other thing to understand is that even if the statutes were to apply, what they prohibit Virginia from doing is altering a siting location. They do not prevent the agencies from denying a certification. Alter means to change or modify. It does not mean to deny. So just based on the plain language of the statute, even if they were prohibited from altering the siting location, they were still required to deny it if a better location was available.
But they were prohibited from altering those upland portions of the large pipelines. You agree with that? Doesn't that effectively keep them from altering the siting determinations for the stream crossing portions too?
Not necessarily. They can't alter when they're issuing a...
Would one not affect the other?
There may be some alteration of where the connection is based on the location, but that prohibition on altering upland locations is during the course of issuing the upland certification, which was done in 2018. It's not at this time. The state has the authority to require, and it is in fact required to, examine whether a crossing location is has alternatives, and it's within, as this court recognized, and as in Mountain Valley Pipeline versus North Carolina, and as the Constitution Pipeline case out of the Second Circuit says, that it's well within the scope of a state's power to regulate the location of a water crossing. And if there were any question about this altering versus denial issue, then Section 81H would answer that question. And that comes immediately after that upland prohibition that you were talking about, Judge Wynn. It says nothing in this section shall restrain the state's authority to deny a certification.
But isn't 81H really just about ensuring that the agencies take some action on these upland permits for long pipelines, even if that's a denial?
I believe that's one way to read it, but if it is a denial, they can deny, one of the reasons available to them to deny, which comes from the Virginia Water Permit Program, is an absence of sufficient avoidance and minimization. It says nothing in this section shall be construed to prohibit the denial of a certification.
Well, you're saying 81H has this loophole is created for 81F. There's no such provision under Section 21 saying that?
I don't think it's necessary.
Difference? You don't have a similar loophole for Section 21 reviews?
I don't think it's necessary because what 81H tells us is what altering means. What 81H is telling us is when the General Assembly prohibits altering, altering does not mean denial. And because the same word alter is used in both 81F and 21D2, its meaning must be the same in both locations.
But there's no similar provision for this in Section 21.
That is correct. There is no similar provision to 81H.
Doesn't that make a difference? I mean, it looks like me, you ought to have that same kind of loophole for Section 21 reviews if you're going to carve out one for 81H.
I don't think it's necessary, again, because of the well-established principle that when the General Assembly uses a word in one part of the statute, it means the same throughout. When 81H provides context for what alter means, it also provides context for what alter means in 21D2. The agencies retain the authority to deny a certification where the location is not the most preferable. But that was not the only flaw here. The other important flaw that this court should take a hard look at is that the agencies uncritically accepted Mountain Valley's preferred crossing methods as the least environmentally damaging practical alternatives, notwithstanding numerous red flags in the record. Rather than examine MVP's alternatives analysis in Table 15 with scrutiny and explaining their acceptance of it, the agencies blindly accepted it, with the permit writer telling the board, in his own words, but in the crossing analysis for the table.
What's our review here?
Your review?
What's the question you bring up? What's the review?
On the question of methods, the question is whether it was arbitrary and capricious. And it was
Look closely at the data provided, including hundreds of crossings that were not statutorily required to be evaluated.
Well, because they voluntarily required those, we haven't briefed the issue of whether they were required to, but we know at least some of these crossings they had to take a look at.
When they look at hundreds, they look at data that's provided and then these hundreds of crossings. I mean, our review is arbitrary and capricious.
Yes.
Pretty high.
And it's arbitrary and capricious for an agency, whether it's a federal or a state agency, to ignore.
What we do.
I understand.
Looking at it.
Right. It's arbitrary and capricious when they fail to examine contrary evidence in the record, or they entirely fail to consider.
You're saying they entirely failed to consider everything that you wanted them to consider.
Yes.
What is your best argument on that? What's your best point that they completely ignored something in these? I mean, it looks like they considered 8,000 comments and asked clarifying questions and followed up. So what is the worst thing they did in your view?
Well, there were 7,500 of those 8,000 comments were apparently form letters. But of the comments, they ignored expert critical commentary of Table 15, that Table 15 was inconsistent, that there were places like the Blackwater where they said that a 39-foot bore pit was too deep, and at least 4 other locations where they, were going to dig bore pits even deeper, including on the Gauley River. So they ignored expert commentary suggesting...
Where in the JA is that?
Certainly.
Whose expert commentary?
The expert commentary was submitted by the petitioners, and that is the Silvas report at JA 1840.
Did they respond to that commentary at all?
There is not a word about it. There is not a word in there about the expert commentary.
And then what was the JA site?
The JA site for the expert commentary is 1840. That's where the Silvas report starts, where she highlights inconsistencies in Table 15 that had to be addressed. They also entirely failed to address MVP's flip-flopping on what methods might be acceptable. There were credibility issues on whether, when MVP asserted that certain crossing methods were infeasible, and the agencies entirely failed to address that.
Or is it reevaluating based on the information they had?
Well, you might excuse it as reevaluating if all we had were their initial statements like about the Greenbrier, the Gauley, the Elk, which you may recall were at issue in a prior case. It may have been a reevaluation over the course of years. But with 38 crossings that they certified to FERC were well suited for conventional boring in November 2020, and then in November 2021, suddenly those were no longer practicable. That starts to undermine any question that it's a reevaluation. And even if it were a reevaluation, it calls into question their analysis because they certified to FERC that they were well suited. And so in the absence of any review of that, and again, this is another example where the agencies entirely failed to consider the questions of MVP's technical analyses, that is arbitrary and capricious, Judge Wynn. And
Why is that not credibility?
why is that not credibility?
We're looking at basically what they did and balancing how they did it.
Well, the D.C. Circuit held in the Colorado fire sprinkler case that it is arbitrary and capricious to fail to examine questions of whether statements are trustworthy. And while there may be, if the agency had made a credibility determination, maybe we would be in a different posture, right? Maybe there would be some deference to a credibility determination, but they simply ignored that issue and didn't evaluate it until they provided examples in their brief. The final example where they failed to deal with contrary evidence in the record is EPA's comments. EPA submitted comments, and these are in the JA at 535 to 536, 2 pages, or a page and a half at least, on their criticisms of the least environmentally damaging practical alternatives analysis. The DEQ fundamentally misunderstood what EPA was asking for, saying all that EPA had asked for were some revised costs. That is flatly contradicted by the record, and that kind of misapprehension of the record is arbitrary and
So
capricious.
they did respond to the EPA. You're saying they just misunderstood what the EPA was saying.
That's correct. There is a response in the record to the EPA, but they fundamentally misunderstood what EPA was saying and said that they were satisfied when in fact there's no evidence that they were. I see that I'm over my time, so unless there are further questions, we respectfully request that the court vacate the certification.
Thank you, Mr. Tierney.
Good morning, Your Honors, and may it please the Court. I'm Erica Maley on behalf of the State Water Control Board and other Virginia agency respondents. I'd like to address, if I may, the issue of the crossing locations. The Virginia agencies correctly interpreted Virginia law as providing that a state water protection permit cannot be used to alter the siting determinations previously made by FERC. Pipelines are long, contiguous projects. It's not possible for the agencies to require a change in the location of one crossing without that impacting the location of the pipeline elsewhere. As this court recently discussed in the Wild Virginia decision, that means that siting determinations risk shifting environmental impacts or even worsening overall environmental impacts by avoiding an impact at one location at the expense of a worse impact at other locations. And that is why an effective environmental analysis of crossing locations has to consider all potential environmental impacts along the entirety of the pipeline route, including such questions as the length of the route, impact on sensitive resources such as national parks and forests, and impact on endangered species, among a whole host of other questions. Those issues go far beyond the scope of a Virginia water protection permit, which considers only impacts on Virginia water quality and only impacts from construction activities in streams and wetlands.
Is the denial of a certification the same as an altering of a siting determination?
It depends on the grounds for the denial of the certification. We agree that provision doesn't say the agencies have to grant a certification. They still have the authority to deny a certification if they don't believe that the water quality standards will be met. But what it does provide to say don't alter the siting location is it changes how you conduct the analysis of whether the application is the least environmentally damaging practicable alternative. In other circumstances, that considers both what the the agency calls on-site alternatives, how you're doing the construction, and off-site alternatives. For instance, if someone wanted to build a Walmart and that would require filling a wetland, the agency could say, well, couldn't you build your Walmart somewhere where you wouldn't be filling a wetland? And you'd have to go through that analysis of the environmental impacts and whether there are available practicable alternatives.
Did this denial require altering the siting determination or not?
Well, in this instance, they granted the certification.
I'm sorry. So what is your position on whether the state of Virginia can alter the siting determination?
They cannot alter the siting determination made by FERC. That doesn't mean, again, that they don't have authority to deny a certification if they find that the project is going to result in a degradation of Virginia water quality. If you have an instance where the construction can't be done in a way that protects water quality, they could say, we're not going to certify this project. But what they can't...
What about this language your opposing counsel pointed out, except for pipelines greater than 36 inches?
In our view, that language is not part of what's cross-referenced back in such facilities. That such facilities is facilities that are regulated by FERC or the State Corporation Commission, not cross-referencing back except for ones greater than 36 inches.
Then what does except for ones greater than 36 inches go to? What's the point of that?
It goes to when you require an individual permit versus a general permit. So that's in the prior sentence, and it says general permits shall be used for projects under the authority of FERC or the State Corporation Commission, which regulates Virginia utilities, water lines, sewer lines, things like that. And that's except if you have a pipeline greater than 36 inches. A pipeline greater than 36 inches has to be done under an individual permit rather than a general permit. And that was a change that was made in 2018, which was the same time the legislature added Section 81 to also require, essentially codify the upland certification procedure that the agency...
That goes back to Judge Wynn's question about, is there any legislative history that would help us decipher this statute?
Yes, I think the legislative history is helpful here because when the legislature is explaining what they wanted to do, they say they wanted to do essentially two things. And one is they wanted these projects to have to be done under individual permits, not general permits. And the second is they wanted that upland certification to be done for these large pipelines, which the agency was already doing. And they don't say anything about, oh, by the way, we also now want you to consider altering FERC siting determinations. The such facilities language, that language about not altering siting determinations, that was unchanged. So the question becomes, when they added the accept clause to the prior sentence, did they mean to change the meaning of that cross-reference? And I think the legislative history, as well as the overall statutory scheme, including Section 81, demonstrates that they didn't, because at the same time they made that change to Section 21, they added Section 81, including they added that language in Section 81, again saying, we do not want these proceedings to be used to alter FERC siting determinations.
This tracks the Virginia method of statutory interpretation, how you go about it. First, you have to determine whether that particular section is ambiguous. And I take it you are saying there is some ambiguity here. Therefore, the legislative history, which Virginia goes to, is something that supports your case. What about the crossing method here? Isn't there some requirement of an independent analysis? And it doesn't look like there was much done here.
Well, I would respectfully disagree both that there is an independent verification requirement and that there wasn't an independent analysis done here.
But you disagree that there's a requirement that the agency should do an independent analysis?
Under the Virginia regulation that applies, it's the applicant's burden to undertake the LEDPA, least environmentally damaging practical alternative analysis. And the agency is to review whether the analysis set forth by the applicant is sufficient. And so that's why some of it's phrased in terms of, here are all the things the applicant considered, because that's how that process works under the regulation. That's the applicant conducts the analysis, the agency reviews it and determines whether it meets the standards. And so there isn't that requirement that the agency do some sort of independent verification, but also they did do a lot here. There were multiple meetings, there were multiple inquiries. They reviewed every one of the hundreds of crossings individually, even though Virginia law only says you have to review the crossings with a drainage area of greater than 5 square miles. And here,
At that point, that they did do an independent analysis here?
they did a thorough,
And when you look at it, what they seem to have done is to recounted these fact findings and then just adopted it.
well, again, that goes back to the Virginia regulation, which I can find the site for you. The Virginia regulation says, that's 9 Virginia Administrative Code 25-210-80, and it says, again, it's the applicant's burden to conduct it, and the agency does a review of whether there's been an adequate demonstration for them to conclude that Virginia water quality is going to be conducted. So they don't have to do an independent verification in terms of you have to then go out and hire your own agency staffers to conduct yourselves all of the analysis that it's the applicant's burden to do. But they took a very close look at it, and they concluded that the factors that were part of that analysis were the proper factors to consider, and those include things like how deep would a bore be, how deep is the stream, is there karst geology, and the petitioners don't have any arguments that those were not the correct factors to look at in determining what crossing methods are appropriate, and they don't even have any arguments that there's other important factors that ought to have gone into that crossing method analysis that the agencies didn't conclude. And if anything, their arguments appear to be based on a premise that boring is just generally preferable to trenching, and we should have required greater analysis to uphold decisions to trench streams, but that's not the agency's view. Whether boring is preferable or trenching is preferable just depends on the characteristics of the particular site. For instance, if you have a site that would require a deep bore pit, you're going to end up with a large spoil pile, essentially a big pile of dirt that has to be removed from the bore pit before the pipeline can be threaded through it. And especially if you have other site-specific constraints, such as a site with steep slopes, it can be very difficult to effectively contain that spoil pile. And so you can end up with a situation where it's eroding sedimentation into the waterways, and that's not good for the water quality. And so that's why those are the factors that the agencies were looking to in saying, stream by stream, do we think they have shown that the crossing methods here are the appropriate crossing methods
What
to be
about
used?
opposing counsel's point that Virginia didn't respond at all to their comment found at JA 1840?
I think they did respond. Again, they're not going to go through and say, here is our response to each comment in the record with the number of comments, and there's just no requirement that they do that. But they did respond to comments that said there should have been more in-depth analysis or the analysis was inconsistent, and they disagree with that. And that's, for instance, in the presentation that the Department of Environmental Quality made to the board.
So did they ever respond specifically to Ms. Silvas's comment that starts at JA 1840?
That's the engineering criticism. Again, I don't think they responded to it by name, but they respond to the comments that the analysis was inconsistent, and that's discussed in the presentation to the board, and they say, we found these factors to be applied in a consistent and logical fashion. That was the finding they made as to that. And again, it's something of a balancing analysis here. So it doesn't demonstrate an inconsistency to say you're always going to have a cutoff, that anytime a bore depth goes below 40 feet, we're not going to bore. It's a combination of how deep do you have to bore and what does the site look like? Because again, one of the main considerations is, can you safely contain that spoil pile? So on one site, maybe you can, on another site, no. And they did respond as well in depth to the EPA comments. And again, you know, EPA, those were comments EPA actually submitted to the Corps, but the agencies...
Right, and I think opposing counsel's argument there is not that Virginia didn't respond, but that they misunderstood what the EPA was saying. What's your response to that?
I think the response to that is that what they were looking for was to say, what has EPA identified in the crossing methodology where we think more information has been required? And what they identified was more information and more conditions that were needed in the mitigation analysis. And so that was what they required. Now, they're not purporting to say EPA is then going to find all of its concerns have been addressed. Again, the EPA is actually submitting those comments to the Corps, and the Corps proceeding is ongoing. So if EPA has remaining concerns, we would expect that they would address that with the Corps. But in terms of the agency's own analysis, those were the factors that they found that EPA had identified, where they then said, we would like to see further analysis. And then that further analysis was provided by the applicant. In my remaining time, I would like to briefly discuss the jurisdictional question. The petitioners contend that jurisdiction exists here under Section 717R, but their interpretation of that section is overly capacious. The reference to agency actions pursuant to federal law doesn't extend to pure questions of state law. And that's really what you have here, especially if you look at their first argument. They're saying the state agency misinterpreted a state statute. And as my friend recognized, it's long been the rule under the Clean Water Act that a Clean Water Act certification that's challenged on state law grounds is considered in state court. And it's our position that 717R didn't intend to change that. And so for those reasons, we would ask that the court dismiss the petition or alternatively deny it.
Is this new enlightenment that you come to this conclusion about jurisdiction?
It
We've been litigating this case for a long time. Is this new enlightenment?
It wasn't raised in previous cases, that's true. I think
That's an understatement.
It is, it's a somewhat new statute, and for instance, the Fifth Circuit case in the Shrimpers concurrence, I think is illuminating as to the jurisdictional issues here. So it's true that we hadn't raised this previously, but again, in every case, the parties in the court do have to do an analysis of jurisdiction. And in some of those prior cases, you may have federal issues. And if you have federal issues that arise with a Clean Water Act certification, those are appropriately in federal court.
717R? Wasn't that
Yes, Your Honor.
2005?
Yes, Your Honor. So,
What are you talking about? Something just came up.
well, we're saying we haven't raised it previously, and there haven't been a large number.
The whole point, that's what Judge Brady
Yes, no,
brought up. You said, well, this is something new. Maybe 2005 does sound new to someone my age, but I'm not sure it's new to you. But let me ask you on that, because I think this jurisdictional issue goes to the heart of something else. The statute, it says pursuant to. It doesn't say applying solely the federal law. Isn't that a distinction? And do you really need to harp on this?
What's that, Your Honor?
Do you really need to harp on this whole issue here when you have that language there and it says pursuant to federal law? And that's really the question here, not solely on federal law.
Well, the proceedings here, they're they're issuing a Clean Water Act certification pursuant to federal law, but they're also issuing a Virginia water protection permit pursuant to state law. And so if you look at the JA1 that my friend was citing, it says pursuant to the Clean Water Act, and it also says pursuant to state water control law. So it is not a proceeding that's solely
If it is
pursuant.
pursuant to federal law, do we have jurisdiction?
I don't believe you have jurisdiction over the claims raised here, no. If the claims raised,
Answer that question insofar as the general jurisdiction question. The statute says acting pursuant to federal law. So here you have agencies, looks to me, and you can convince me otherwise, that they're acting pursuant to Section 401.
they're acting pursuant to Section 401 in issuing the Clean Water Act certification, but they're acting pursuant to Virginia law in issuing the Virginia Water Protection Permit. And the pipeline would have to obtain the Virginia Water Protection Permit, even if the Clean Water Act didn't exist or accepted this project. That is an independent requirement of federal law. So the fact that it also serves as the Clean Water Act certification doesn't transform everything that happens into the proceeding in something that's done pursuant to federal law. And there is no argument here that, for instance, not evaluating crossing locations somehow violated the Clean Water Act. The Clean Water Act doesn't require that. Petitioners never
If
argued
this is
that.
all about state law, then maybe you could alter it, alter FERC's siting determination if state law is what we need to look to.
Well, it's a state law provision. It's a state statute that says that the state agency cannot alter the FERC siting determinations. So that's why, in this case, that is a pure question of state law that ought to be in state courts. Thank you, Your Honors.
Right? Sibley?
Apologies. Good morning, and may it please the court, George Sibley for Mountain Valley Pipeline. I'd like to start first with just one point on the statutory interpretation point and whether Section 21D2 exempts these large pipeline projects, or that the restriction there applies to these large pipeline projects. As my friend noted, the 2018 legislation does two things quite clearly. It directs for individual review of large pipelines, and it creates this upland review that previously, that's what this court reviewed in the 2018 decision, but that there previously had been no statutory grounding for that. And Judge Wynn, you asked the question about ambiguity and resort to legislative history. I would suggest there's a step the court could take before that, and that's to read the legislation as a whole, and in particular, the actual individual review that's prescribed in subsection J of 21.
Explain that to me. I'm sort of trying to grappling with this whole business of statutory interpretation. What is our review? Do we look back at the beginning of things or what? I thought Virginia's pretty clear. You first, if it's plain, that's the end of it. There's no step before ambiguity. If it's plain, you go with that meaning.
Yeah,
but if it's ambiguous, that's when we go to intent of legislation. So what are you talking about? There's a step before ambiguity other than the plain.
I think we actually agree with one another. I'm referring to not the finding of ambiguity, but the resort to legislative history as a way to resolve that ambiguity. I think there's an intermediate step there, and that's to look to the words in the legislation as a whole. And in subsection J, which
Plain meaning.
the plain meaning, yeah, but as
You're just saying look at the statute for the plain meaning. But when you use it, look at the history of it, you were confusing me.
okay,
I don't like to be confused
yeah,
because I get off track when I get confused. So
me too, Your Honor. I was simply saying the canon of interpretation that you interpret the specific provision D2 in light of the statute as a whole, and certainly in light of the legislation that augmented the review here. And in subsection J, there are several powerful textual indicators that the legislature did not intend to mandate that the Department of Environmental Quality undertake this type of sweeping review. Among other things, they say that these individual crossings that they're supposed to evaluate are to be considered single and complete projects. So when you're looking at alternatives to the project, you're necessarily constrained to that particular location. Second, they only tell the legislature only asks that they consider certain of the crossings, those that drain an area of 5 square miles or greater, you simply cannot conduct a comprehensive siting analysis of the type that my friend described that involves a balancing of considerations across the entire project without looking, if you're only looking at a handful of crossings. With the balance of my time, I'd like to focus on the petitioner's arguments concerning Mountain Valley's demonstration that it had minimized impacts to the extent practicable. Now, I think as is noted and as the court and my friend discussed, it's simply not correct that the agency blindly accepted what Mountain Valley submitted. There was an extensive process, and that's documented in the record. Ultimately, what is required for the agency in their decision document is to provide a clear and concise statement. What the board is supposed to provide is a clear and concise statement of its decision. And it provided that here. It adopted in full DEQ's fact sheet and the recommendation, and that recommendation and the fact sheet discuss at length this particular demonstration and all that the agency did to verify it. Now, Judge Thacker, with respect to the question you posed concerning the evaluation of this particular expert report, I think the best case on that is this panel's decision in the North Carolina case, which discusses the agency's burden in providing a description for a decision document, what it needs to include in the decision document. You recall in that case that the North Carolina Department of Environmental Quality denied Mountain Valley's request for a 401 water quality certification for the Southgate extension for the project. And the basis for that denial was the uncertainty over the mainline project. And in response, in part of Mountain Valley's petition in that case, we argued that the agency needed to consider one piece of evidence in the record that more fully and explain it better. We had provided a chart and that documented all the pending cases, and we wanted some sort of quantifiable metric to explain how the uncertainty there precluded them issuing a certification. And the court said that's not necessary. And we looked to the whole record, and there's ample evidence in the record here to support the underlying decision. And I think the same applies here. The issue about the practicability of alternatives was one of the most thoroughly discussed issues in the record. The agency did not directly address Ms. Silvas's, I see I'm out of time, if I could briefly finish, did not address the particular expert report, but Mountain Valley did, and that is in the record. And the court's duty, certainly under Virginia law and reviewing agency action, we do think that provides a rule of decision, is to confirm that there is evidence in the record to support the agency's decision, and here there is. We think the court should deny, should deny the petition. Thank you.
All right, thank you. Mr. Tini? Yeah.
Thank you, Mr. Chief Judge Gregory. A few points on rebuttal. Addressing jurisdiction quickly, I heard it proposed that the questions presented by the petition involve pure questions of state law. There can be no pure questions of state law for a Natural Gas Act facility because those would be otherwise preempted. That Virginia Water Pollution Permit Program, the permit itself only exists because the Natural Gas Act preserves 401 authority. That's the only way that that applies. So there are no pure questions of state law. Everything is bound up with Section 401. Coming to the methods analysis, they do have a duty to independently analyze. Yes, it is the applicant's burden to provide the alternatives analysis, but that analysis must demonstrate to the satisfaction of the board, which requires the agencies then to take a look at it and verify it. And when there is contrary evidence in the record, that must be dealt with, even if Virginia law provides the rule of law. In the case of James versus City of Falls Church, cited in the brief, a 2010 Virginia Supreme Court decision at 694 SE2D at 574, an agency action has to be vacated where it's issued without consideration or in disregard of facts or law. If there's contrary evidence in the record, it must be grappled with, and here it wasn't. And digging down, pardon the pun, on the crossing methods and the questions that Virginia was presenting about how deep the bore pit must be.
What contrary evidence are you saying was not grappled with?
There were three things on methods. The contrary evidence in the Silvas report, the inconsistent statements made by MVP over the years about whether a crossing was unfeasible and then it was feasible, and then EPA's comments. Those three things were inadequately dealt with in the record. The Silvas report, for example, calls out that there are 44 sites in Table 15 where Mountain Valley complained they didn't have room for spoil.
Does inadequately dealing with them rise to the level of arbitrary and capriciousness?
It does. In the case of the critical commentary and the credibility issues, there was a complete failure to address. And so therefore that is...
Critical commentary is the expert?
Again, that is, yes, it's the Silvas report at 1840. So that complete failure to address is arbitrary and capricious. It's also arbitrary and capricious.
Well, opposing counsel said that first of all, the state did address it, maybe not directly, but in an overarching way, and that MVP addressed it.
Well, I would disagree that the record reflects that it was addressed by the agencies. And to the extent that MVP addressed it, the agencies did not adopt that rationale. You know, MVP provided a lot of responses to the comments, and I can't think of an example offhand where...
Do you want them to adopt MVP's rationale?
Well, no, of course not. Okay. But we need them to explain either why they did or did not. I mean, that is simply the issue. For example, on the question of their credibility, MVP explained that, well, after we submitted that application to FERC and certified that it was true and correct, we determined that it was logistically difficult, even though they were technically practicable. Well, that explanation falls short because the whole question is whether it's practicable. So I don't think they could have explained that away or adopted it rationally. On EPA's comments, EPA wanted more information than just to consider the costs of mitigation. But when the board asked DEQ at the hearing, well, were EPA's comments addressed? The board, the DEQ permit writer said the main thing EPA wanted were costs, and I wasn't aware of anything else they wanted. But that's contradicted by the record. There is record evidence that they misapprehended what EPA wanted.
That's why you're saying they misunderstood EPA's comments.
That's correct. That's correct. Because EPA didn't just want to understand the costs of mitigation. They said that we do not think on this record these methods are the least environmentally damaging practicable alternative. We need you to more thoroughly explain why you've rejected trenchless crossings, and we want further consideration of trenchless crossings at every location. And that was not provided. And DEQ missed that, instead focusing on this narrow question of mitigation costs. Quickly, with my remaining time, on the question of 21J raised by MVP's counsel, yes, that does provide that each crossing is a single and complete project, and that means that the avoidance and minimization requirements must be viewed through the lens on looking at that crossing, not looking at its effect on the rest of the route, but whether that crossing, its location and its method, is the least environmentally damaging. And so I don't, to the extent that 21J informs the analysis, I don't think you need to get there. The language is plain on the meaning of alter. But to the extent that it informs the analysis, it suggests that it is looking at that narrow crossing and not at the route overall. So for those reasons, we respectfully request that the court grant the petition and vacate the certification. Thank you, Your Honors.
Thank you, Mr. Tenney. Thank you, counsel all, and appreciate your arguments. Schwaber?
Thank you, Your Honors. May it please the court, My name is Andrew Schwaba from Charlotte, North Carolina, and I represent the plaintiff appellant Chris Hill in this matter. Your Honors, the issue in this matter is whether approximate cause is a jury question where all relevant parties who read a system of warnings provided by the defendant's surtext came away with the impression that the warnings advised them to avoid sharp edges while using nylon web slings. The plaintiff testified that it was his understanding that he was required to avoid sharp edges. His coworkers testified that they had the understanding that they were to avoid sharp edges. Tancarva, the plaintiff's employer, their trainer and representative also testified that it was sharp edges that were needed to be avoided. The North Carolina OSHA inspector who testified also said that she was under the impression that sharp edges had to be avoided. And even the Surtex sales agent testified that sharp edges had to be avoided. And that's at Joint Appendix 313 to 314, Your Honors. The source of that confusion and what our experts have termed critical confusion came from the warnings as a whole. And even the Surtex CEO in this matter testified that the warnings had to be read together as a system. That system was composed of 4 different pieces. A weight load limit tag that was stitched directly onto the nylon web sling, a warning tag that was also stitched onto the nylon web sling, a safety bulletin that was zip tied to the web sling, and an online product catalog that was also delivered with the nylon web slings to their customers. That was an application instructions, warnings and applications instructions that also had the subtitles operator's instructions.
So let's think about this. In North Carolina law applies.
Yes, sir.
Negligence,
Indeed.
contributory negligence.
Yes.
So when you look at this warning label and this safety bulletin, it does indicate some warning there. It tells you you need to use padding on any edges of the corners. Mr. Hill didn't do that.
Well, that's correct, Your Honor, because he had the impression, he understood those warnings to mean that only sharp edges needed to be avoided. And the impression that he received...
Do all those warnings say that? That only sharp edges need to be avoided?
Not all of the warnings, of course not, Your Honor, no. There obviously...
Any edges or corners.
I'm sorry?
Any edges or corners.
To protect the sling, that's correct, Your Honor.
Let's use padding on any of the edges or corners. He didn't do it.
It does say that, Your Honor.
Also, it's true he didn't do it.
He did not do that, nor did he believe it was necessary because he felt
Where does
around...
that come in with contributory negligence? That
Well-
whether you believe it's necessary. If there's something that tells you to do something, you fail to do it, the fact of whether you believe it's necessary, how does that... Yeah, I'm with you. I mean, I've been dealing with this contributory negligence in North Carolina all the time I've been in law, and of course it's been there forever, but North Carolina's one of those states.
Right, unfortunately...
And so it's clear here, he didn't do that.
No, he didn't, nor did he believe it was necessary, nor did our experts in the industry tell us that he needed to do that if he followed the instructions, because although there is...
See, that's where I'm going. Defense of contributory negligence. I mean, there are some ameliorating conditions. I mean, in automobile accidents, you have like last clear chance, all kinds of stuff. Where does he didn't believe it's necessary come in as an ameliorating defense to contributory negligence? I'm intrigued with that. That's if it exists. What's the case law for that?
Well, I don't know that there's case law on such a fact-specific matter, Your Honor, but what we have here is a system of warnings, and those warnings need to be interpreted as a whole. Instead of reading in isolation one clause of those warnings, when you look at the warnings as a whole, where you have a warning tag that refers you to some operator's instructions, that when you look at the operator's instructions, if you just go by the document that is titled operator's instructions, that's an online product catalog. That online product catalog says avoid sharp edges.
When we're looking at the whole, and and I'm going there. If we were in comparative, we'd be talking a different thing. But it also warned him not to put that choke point against the eye of the sling. And
That's correct, Your Honor.
he ignored that.
I would disagree with Your Honor. He did not ignore that. So when you're looking at putting the eye of the sling on the choke point, the way this sling was choked was on the body of the sling. There's always one eye involved. So if you have one hole at the top that's hooked on the clamp, the other eye was not on the other eye of the sling. It was on the body of the sling. And so he had choked it down, and the choke point was on the body of the sling as the manual instructed him to do. And in fact, the weight of those plates was also on the body of the sling. It was the top eye of the sling on the top of the plates that was cut here.
But when you look at this thing realistic, it's a tragic situation. I mean, it's horrible to read the facts of what happened here. We're in North Carolina again.
We are.
You are in a machine or something, and you're lifting this heavy item up, standing up with this strap, I would call it, best I can say.
Yep.
You walk over there to it. This thing breaks, and you get injured. It just looks dangerous, even if the straps were working. But here your question is, your statement says you didn't warn me of this. But
Well,
it tells you what you've got to do, and he didn't do it.
with all due respect, he did follow what it told him to do.
Did it tell him to walk up next to this huge item that could fall on him and trust those straps so that it won't fall on you?
Well, you're asking two questions. First of all,
Answer both then.
did it tell him to trust those straps? And it certainly did. It told him that weight was going to be within the weight that he had, 700 pounds per plate, 1,400 pounds, was going to be within that 2,400 pound weight load limit that the strap indicated it would. So he certainly trusted the straps to support the weight. The second question that you raised, though, is was he in that fall zone? And what he's testified and what our experts have said is that he did not do anything wrong because he did not believe that he was in a fall zone. He was 6 to 8 feet away from these plates as he was raising them up. They were both approximately 6 feet in height. And as they fell, they pivoted on their corner to now create the situation where he was in the fall zone. So at the time, the way he read those warnings and the manner in which he read those warnings were perfectly appropriate according to the warning specifications. And that gets to our larger issue of the implied warranty of merchantability here, Your Honor, because we do believe that he had used the product in accordance with specifications.
Thing here a little bit, just we'll get the
Of course.
Now you said he should have warned, Cortex should have warned you about the load limit issue?
Right, so we have a separate issue, a separate theory of negligence. That is the weight load limit classification here was incorrect because Certex never warned the plaintiff to avoid putting that, to avoid coming into contact the load with the single ply of the eye and the fact that that would reduce the weight load limit in half.
You made that argument below.
We did. And we included it in our brief to the court as well, Your Honor. Because what happened here is there's a single ply of the eye, and then there's the double ply within the body of the sling. And when you apply any pressure or any surface to the single ply of the eye, and the eye can cut because the weight load limit is cut in half, that also was a defect in the warnings Certex supplied.
Tell me where you, in the record, where you raised that below.
Certainly, Your Honor.
When you come back.
Certainly. Unfortunately, I don't believe we were allowed to include in our appendix the briefs from the parties, but we certainly raised that issue.
I'm just asking you to tell me where it is.
I will do so. I will do so.
You do include that in the record, don't you?
We do. We do. Yes. Thank you, Your Honor. So we have critical confusion here within this warning system from the defendants. Within those four pieces, we have the warning tag that refers to the safety bulletin, even the safety bulletin.
In your briefs, you argue that it was appellee's warning tag advised the user to avoid only sharp edges. What warning tag
So it's the,
warned against only sharp edges?
well, so
You cite JA 483, but that's not the correct tag. That's not the tag that was in use when this accident occurred.
right. So we have
So that's right. So are there any?
yes. So there is a surtext warning tag that was initially applied to the web sling and had been applied.
That's not the one that was in use when the accident occurred.
It was not,
So why does that matter?
because.
I mean, yet that's the only thing you cite in your briefing for your argument that the tag advised the user to avoid only sharp edges.
That's correct, Your Honor. So, first of all, I don't believe our brief said that the system said only avoid sharp edges. It said avoid sharp edges. I disagree with the circuit court's characterization of our
To
argument.
avoid only sharp edges.
Yeah. So that was certainly our client's understanding, the plaintiff's understanding here, that he had to avoid only sharp edges.
That
Nevertheless,
was attached to this sling?
so it was not attached to this sling. The surtext tag had been used for 5 or 6 years, actually since 2005. Two slings exactly like this. Our plaintiff had read those slings, had read those warnings. Then
Did the tag that was attached to this sling use the term sharp?
it did not.
Okay.
It did not. And so for approximately
Walk
one,
me through that.
pardon?
He read something about it being sharp edges. I understand, you've been doing something for years and years. But the tag on this one doesn't say that. It says any edges.
That's correct, Your Honor.
And so, walk me through that. I'm having some difficulty understanding how that's a failure to warn for that sling.
Because even that warning tag, Your Honor, refers the reader back to the safety bulletin, and the safety bulletin refers readers back to their operator's instructions of their catalog. And the catalog,
I don't mean to interrupt you, but I'll make sure I understand that.
certainly,
If you have a broader statement insofar as this sling says you are to use it on any edges, it said you can refer back, and it says a more specific thing, sharp edges. Why would the sharp control over that's on that sling?
see, I think it would, Your Honor, and that's what our expert
I
testified.
understand what you think, but I want to have a little bit more than that. I want to have, and I don't mean to not accept at least your thoughts on it, but I'm trying to understand in terms of where you have something on that sling that tells you the warning, because you said, he didn't warn me that this would happen. It's right on the sling, but you said it refers back to the, to a panel that says sharp, but here it says on that sling, any. How do you narrow that, what's on the sling, by what's in that panel?
Even the Certex CEO, Your Honor, said that he did not expect all of the users to read these warnings every time they used the sling. And that explains why our expert says,
That goes to just about any dude that warn. Who reads those warnings? I mean, when you really get down to it, most of them is fine print up there. Who goes up there and actually reads through every one of those warnings? But the law holds you to it when you say you didn't warn me. If you didn't warn me and it's right there and it's in writing on it, the fact is you didn't read it, is that a defense?
well, it's a defense in the sense that our client did read these warnings.
The one
And-
on the sling.
He read the warning on the sling, he read the safety bulletin, he read the online product catalog, and came away
Well,
with that.
then the warning on the sling said all edges. It didn't say only sharp edges.
Well, so it said it should be protected from corners and edges.
Right.
And
It
then
didn't say sharp.
It did not say sharp. And then referred it to the safety bulletin. The safety bulletin referred it to the online product catalog, and he has a 5 or 6 year experience using these slings that say warn sharp edges. And so our expert says, in addition to that, if you're going to make a change like that, to a product where it's it has the potential to be very dangerous, you have to provide training in addition to a warning like that. I see that my time is now up. Thank you, Your Honors.
Let me ask you one question on that.
Certainly.
So I understand where you're going. What if it had on that sling that you have to have a padding on the edges? It says you can refer back to this manual. The manual says you don't need padding.
Well, that's part of the critical confusion, Your Honor. We think that results in a question of proximate cause.
But you don't think that saying on the actual thing you're using is a warning? In other words, that warning is then undone by some pamphlet that says otherwise, even though it's right in front of you as to that specific item.
Well, I think you have to put the whole thing into context, because as the defendant's testified, it's a system. So you can't read one thing in isolation and say that you can ignore the rest of it. And in the same way that you can't slip one sling in with one word different and say, all right, ignore 6 years of history in the way that you've read these. Ignore our product catalog. Ignore everything else that you've read and understood about using these slings for years. So they have to be read as a system. They have to be read together, and they have to be put in context rather than in isolation, Your Honor. Thank you.
Thank you. Mr. Sabara?
Thank you. May it please the court, Judge Gregory, Mr. Schwab. I'm Luke Sabara. We represent Certex USA. I think the court has hit the nail on the head with respect to many of the issues in this case. As your honors know, the issue in this case is whether Judge Catherine Eagles properly granted summary judgment with respect to the three claims below, which were the breach of express warranty claim, the breach of implied warranty of merchantability, and the product liability claim, which arose under North Carolina General Statute 99B. I will very briefly address the breach of express warranty claim. That claim was not briefed in the appellant's opening brief. I believe it's waived under Rule 28.
The negligence claim, that's what we spent a lot of time
All
on.
right, let's talk about the negligence claim. I believe Judge Thacker and Judge Wynn hit the nail on the head. The safety bulletin that Mr. Hill testified to in his deposition explicitly warned against any edge, not just sharp edges. So did
Why is the pamphlet saying something different?
the pamphlet doesn't say anything different.
Where does the sharp edges come from?
Okay, the word sharp edges it is in the safety bulletin that Mr. Hill testified he read. It says, read and understood and had no questions about. It says surfaces in contact with the sling do not have to be abrasive or have razor sharp edges to create the conditions for sling failure. Therefore, web slings always must be protected from being cut or damaged by corners, edges, or abrasive surfaces.
Now, at some point, didn't one of these warnings say sharp edges only?
Correct.
Yes, okay. And so this, I think it was described as a system of warnings. And here we have a number of appellant's coworkers also testifying that they thought the warning only applied to sharp edges. Isn't that some indication of confusion, at least, and a failure to warn?
Well, I think that would be some indication of what the coworkers knew, but that doesn't negate Mr. Hill's specific knowledge. On this particular web sling, we know, and there is no contrary evidence in the joint appendix or in the depositions below, that there was a warning tag from the WSTDA, which is the Web Sling and Tie Down Association, which Judge Thacker, you addressed, that specifically says that not only sharp edges need to be protected, but all edges need to be protected. And Mr. Hill testified that he read that warning tag beforehand. And we know that warning tag.
And which ones, in the deposition testimony, I understand that he said he read and understood the warning. Which one was he reading?
Yes.
Which one was he shown
So
at the deposition?
He was shown an exemplar in the deposition of the web sling, and he said, this appears to be the web sling by physical characteristics that I used. It was a 3-foot nylon web sling. He could not identify and say it was the exact same one. But we know from the 30B6 deposition of Mr. Evans, that who's at the time was the CEO of Certex, that the Web Sling and Tie Down Association warning tag was used, and he knew that because the warning tag was clipped off of the
So really, that deposition is not a model of clarity as to what he read and understood, because there were a system of warnings here, and it's not clear what he read. It is clear from his testimony what he understood is that he was only to avoid sharp edges.
Well, it's clear that he looked at the warning tag on the web sling that failed. He read the warning tag, and it's clear. There's no contrary evidence that the Web Sling and Tie Down Association warning tag was on the web sling at some point. Mr. Hill reviewed that warning tag, which says nothing about sharp edges, nor does the safety bulletin, which he read and understands, say anything about sharp edges. It talks about protection.
But just to be clear, nobody handed him at the deposition, here's the warning tag that was on the sling at the time of the accident. Did you read this and did you understand it?
No one did that exactly because Mr. Hill's employer, during the pendency of his worker compensation case, destroyed the web sling. In November of 2018, the web sling was cut in pieces and put in the garbage. Ten Carver's employer used the web sling, according to their deposition testimony, as a show and tell of what not to do in their place of employment. Then, before the lawsuit was filed, one of the employees, one of the managers, I believe the HR manager, cut it in pieces and threw it in the garbage. So it wasn't available, which may present a spoliation issue, but that's neither here nor there. But to answer, you look like you have a question. To answer your specific questions, there's no question at all. There's no evidence to the contrary, and this is why I believe Judge Eagles was correct, that Mr. Hill was on specific knowledge, whether it's a system of warnings or whether it's an isolated warning limited to the safety bulletin, that he was to protect the web sling under all circumstances, and that there doesn't need to be one specific condition that can give rise to a web sling failure. A sharp edge or any edge can create the condition for a failure, and he knew that. He testified he knew that, and he testified that he didn't have any questions about that. And the analogy I draw is sort of like, and the argument that Mr. Schwab is making is, well, there was an obligation.
Where was it that he testified he didn't have any question about that?
In his deposition.
Which JA, I'm sorry.
Sure. I don't know the joint appendix side, but I know he testified very clearly in his deposition about that. And Mr. Schwab asked him about that as well. And I asked him, Mr. Hill, is it your contention in this lawsuit that you were not made aware of, is it your contention in this lawsuit that you were not warned about sharp edges as opposed to any edges? Yes, that's his contention. Mr. Schwab asked him the same question. Same thing with their warnings expert or human factors expert, Mr. Maddox. He said, this lawsuit arises because of the confusion about sharp edges versus any edges. And the safety bulletin covers all of that. It covers that in the third warning about protecting the sling from damage.
What's your response to opposing counsel's point that I think he said the CEO testified that he didn't expect everybody to read all of the warnings?
Well, the CEO, Glenn Evans, testified that sophisticated users use this product. In other words, it's not sold in retail stores. And he also testified that what he expected is users to read the warnings and to understand them before they are used. And that's exactly what happened here. And that's what distinguishes this case from the cases that the plaintiff's counsel has cited, because and I'm referring to my notes briefly, but the cases that the plaintiff's counsel cited all have conflicting issues of whether or not the warnings were read or whether they were understood. In the Champs case, there was a question about the warnings. That was the North Carolina Supreme Court case. The employee had ordered a dust product, and the wrong product was delivered, but the correct instructions were applied. In the Bryant case, there's a question about whether the instructions were even provided at all. That's not what happened here. Mr. Hill knew exactly what was happening, and he made a poor decision. We are not our...
That's really the question here. It's a very tragic situation.
Yes.
Hill was not a novice doing this sort of thing. So you have this, I think one of his experts said that padding, we went back and forth on the padding. He said it wouldn't matter because of the way that eye was placed directly on it, that actually cut the weight load in half. Follow me. I'm just going based on what they're saying. I'm going to ask you to give me the mechanics of it. But But Mr. Hill said he didn't put it on that eye. So if he didn't do it, what does that mean? In terms of the mechanics, how does this happen with this kind of equipment? If he didn't put it on the eye, the expert said it wouldn't, the padding wouldn't have mattered.
That's a great question, Judge Wynn, and there's a conflicting versions from each expert about how this happened, and the safety bulletin covers that exact situation. Safety bulletin says that there does not need to be a specific failure mechanism for the sling, that sling failures can occur almost under any circumstances, that there should be padding, and not to use the eye. I know you're saying in your situation, according to the appellate's contention, they did not choke on the eye, but we differ, and so did North Carolina OSH about how that occurred. But that's sort of a factual situation. We think that's not material to the outcome. What's material to the outcome, we believe, is that he was warned and that he knew exactly what he was getting into. And again, I understand, contributory negligence is generally a question for the jury.
He was warned to do what?
On the safety bulletin, he was warned, and by the warning tag, he was warned that there can be a condition for failure under any circumstance. It's not just because of a sharp edge, but any edge, and that slings always need to be protected, and slings can be damaged, abraded, or cut, and compression between the sling, as compression between the sling and the connection point and the load develops. So he was warned about that, and he said he understood it.
But if I understand the expert said doesn't matter whether or not you did it or did not in this case because of where that eye was placed. But Mr. Hill said he didn't put it on that eye.
Right.
What does that mean in terms of summary judgment?
Well, yeah, that's another. That's warned against. Choking on the eye is warned against, and that's another thing that Mr. Hill would have known about and should not have done. And the experts disagree. Our experts said he choked on the eye. I believe North Carolina OSH said, and I understand the appellate's contention that he didn't choke on the eye and he wasn't warned about that. But the warnings fortunately cover every single aspect of potential failure. And his employer, Tancarva, said this was a good employee who made a poor decision. Tancarva was fined or cited and then paid fines by North Carolina OSH because of this situation. And Mr. Hill knew, and the argument from appellate's counsel, my friend Mr. Schwab, is that Tancarva had this responsibility. And that, to me, turns the notion of Mr. Hill's knowledge on its head. The argument is kind of like saying, well, Certex had the responsibility to tell Mr. Hill not to drive through a red light when Mr. Hill already testified he knew not to drive through a red light. What else can Certex do when he's testified that he already knew what the safety bulletin meant, that he understood it, that he had no questions about it, that he didn't need it clarified, and he didn't ask his employer about it? And Mr. Schwab has testified today that the reason he knew not to choke on the eye is because he looked at the manual. So he knew not to choke on the eye because he looked at the manual. What does the manual say? The manual says everything that I've just been explaining, which is that there can be a failure mechanism from almost any way in which the sling can be tied to an object. And
you're saying that insofar as the claim on warning was satisfied to the extent of the padding, and it was satisfied in terms of not choking on the eye.
yes, and because the
Question of whether he did it or not doesn't really go to the warning.
correct. And Your Honor, the case is fundamentally different from the Taser case that Mr. Schwab cited to the court. I'm going to botch the first name, I believe it's Fontenot. But the Taser case involved a situation which this court addressed, I believe, in 2013, in which the Charlotte-Mecklenburg Police Department was not advised by Taser that there had been changes to the particular model Taser that was being trained for use of officers, and there was a cardiac risk. And Taser failed to warn the CMPD and the police officer of the cardiac risk. The training police officer said he absolutely would have wanted to know that there was a cardiac risk. Unfortunately, someone was tased and died by the specific mechanism at issue in that case. I think it was ventricular fibrillation. And Judge Conrad instructed on failure to warn, product liability against taser. The jury found against taser, and this court affirmed Judge Conrad's jury instruction because there was a broken chain of events. Taser had failed to warn. The police officer who was training didn't have that knowledge, and the individual unfortunately died as a direct result of that. That's not what happened here. Certex provided knowledge. Mr. Hill read that knowledge and he understood it, but he unfortunately made a bad decision or a poor decision, and he was unfortunately injured. That's completely different from the taser situation because if the police officer didn't know, Mr. Hill did know, and he knew because he read the safety bulletin. And whether he read it alone or whether he read it as a system, I don't think that's material. What's material is what he knew. And his knowledge is what we believe causes this case to crumble because he knew exactly what he was getting into, and he knew to protect the sling from damage in any configuration. Your Honors, I have not addressed the breach of implied warranty question. We believe that warranty was disclaimed because the warranty language was conspicuous, and that is straight out of North Carolina law. North Carolina General Statute 25-1-201 has the definition of conspicuous, and we know that this particular web sling was sold on June 3rd, 2015, or thereabout, from the deposition of Mr. Evans, and it was sold with terms and conditions that included the disclaimer or the implied warranty of merchantability. There's been no contrary evidence in the joint appendix whatsoever indicating anything other than there was a disclaimer in all capital letters of the implied warranty of merchantability. We have cited a case, Lee versus R&K Marine, that is in our brief, that is on all fours with this situation, in which an implied warranty of merchantability is disclaimed. And that is exactly what we believe here and why this implied warranty of merchantability was disclaimed. We believe that despite the fact that there was mention of the express warranty above the implied warranty language, that does not change the fact that this disclaimer of warranty was conspicuous. There's no evidence at all from Tencarva, and they did file a notice of appearance in this case to protect their workers' compensation lien, that they had any problem understanding the disclaimer or didn't understand what it meant. The only evidence in this case, which is uncontroverted, would be that it was disclaimed, and as the non-movement, the burden would be on the appellant to come forward with some evidence that this warranty disclaimer was not conspicuous, and the non-movement has not done that, and the burden has shifted to the non-movement, and the non-movement did not do that. So Judge Eagles, we contend, was correct in that regard. This case also, the facts of this case with respect to the implied warranty also differ from the cases the appellant cited in his reply brief. That's the Griffin Electronic Consultants case and the Raytheon Air case. In those cases, both of those cases, there were significant questions about the manner in which the implied warranty appeared. In the Griffin case, the implied warranty appeared in two different documents, and there was an issue of fact over whether the service agreement and the quote were one in the same document or two different documents. In the Raytheon Air case, there were multiple documents to consider. So another point with respect to the failure to warn is that this situation is similar to a situation in which an employer would have something like hazardous chemicals or solvents on their property. And Mr. Schwaba's contention is, what's the responsibility of the manufacturer to advise and to tell further. Well, there's a lot of problems with that. Number one, the employee is already fully aware of the risk by the employee's own testimony. Number two, there are federal regulatory requirements that exist for Tencarva, Mr. Hill's employer. They were cited and paid those fines to have a web sling program, a preventative maintenance program. And number two, and number three, the argument from appellant that Certex should have warned further assumes that Tencarva would have accepted that training. It assumes that Tencarva would have paid for that training. It assumes that Mr. Hill would have been part of that training. It assumes that Mr. Hill would have changed the nature of his behavior because of that training. All those assumptions are not in the record. There's no evidence of that. In fact, Mr. Hill was trained in 2009 on web slings. The testimony is he acted contrary to that training. And the testimony from Tencarva is that as a rule of thumb, he should not have used a web sling to move a carbon steel plate. So the argument from the appellant that Certex should have done something, again, runs in opposite to the facts of this case, because Mr. Hill already knew what he was supposed to do. It was Tencarva's responsibility as a matter of federal regulatory law and OSHA law and state law under North Carolina. And number three, it assumes Tencarva would have done something different and Mr. Hill would have done something different. So in sum, we believe, Your Honors, that the district court did not err, and we respectfully request this court to affirm Judge Eagles. Thank you.
I just want to clarify, just make sure, like this. In this record, is it clear that Mr. Hill made the connection?
Made the connection, but I'm sorry, the
Made
physical
the connection to the strap, in terms of, let's be connected to the eye. We talked about the single eye. Is it clear that he did that?
It is clear he did that.
Yeah, he did all the rigging.
He did all the rigging, yes.
Okay.
The experts disagree, Chief Judge Gregory, with respect to the manner in which he rigged the
choke.
to the manner of choking and how. But he did it. No one else did it, and but that issue is uncontroverted. Okay. Thank you.
All right.
Your Honor, what Mr. Sabara indicated just now is correct, that it was Mr. Hill that did all the rigging. However, there are no competing inferences to be drawn between the two experts because their expert was stricken by the trial court at the lower level for not having the proper qualifications to render his opinions. I want to clarify.
What does that mean? What does that mean in terms of your expert? How does that help if
It's
what your opposing counsel just said is correct to Judge Berger's question, that he did all of the rigging? Yeah, he said he didn't put it on that eye, but he did all of the rigging. And then you say there's nothing about the expert because his expert said, well, padding wouldn't matter because his eye is the problem. Cut it in half. How's that help you? I'm trying to understand.
Yeah, because what they said was that he did use the sling so that it was choked on the eye. But he didn't have the qualifications or the background with slings to offer that opinion. And Mr. Mackey.
No, I'm just talking about your expert.
Yeah,
I'm good with it.
Our expert says that he used this sling in a perfectly appropriate manner according to his understanding of it and even according to the warnings. Because our expert was alerting the industry to the fact that users were using these slings without knowledge that any edge or corner can cut these slings. It doesn't have to be a sharp edge or corner. And that's where, if I can make one point related to Mr. Sabara's representations, is that our client, the plaintiff, did not have the awareness of the risk, did not have the knowledge, and did not know that that could occur. He understood, he read the warnings, he understood.
Your expert said, as I recall, it says it didn't matter. It would have failed regardless of the padding. And it doesn't rely on that. What he's talking about is the choke point, touching that eye. Your client said he didn't do it, but he's the only one that did anything to that in terms of the rigging of it.
No, I think the question is that he didn't do it, meaning that the choke point was not on the eye. It wasn't the two eyes meeting on each other. It was the choke point being choked on the sling body itself. And that was the issue, because that is silent in the bulletin and in any of the warnings as to how that's supposed to be choked. That's why our expert did say that the way he choked this was appropriate. That's the way it was supposed to be done, and he did it.
The key being, not to confuse it, we're not talking about how he actually did it. We're talking about whether he was warned about it. And your expert said he did it correctly,
Correct.
but the warning is what we're talking about.
And the warning was inadequate because it didn't tell him that that single ply eye of the sling could be cut when it's on top of the load that it's carrying. Okay? So you have two eyes to the sling, and one of those eyes has to be on the body in a choker hitch. And when that eye comes down on top of the load that it's carrying, that's where the cut occurred. Not on the supportive end of that eye that's actually bearing the brunt of the load, but on the top of the load, the rest of the sling is positioned above that. So it wasn't choked on the eye, because that would be the two eyes being choked together. It wasn't like that. It was choked down lower on the rest of the sling. And so, Your Honor asked me a question to ask or to provide in rebuttal references to the point, references to the manner where in the joint appendix where we had made that argument to the lower court, and the references are JA 1017, JA 928 to 931, and JA 948 to 951, as well as JA 1057 to JA 1068, where our expert, Mr. Mackey, testified in that regard. And so Mr. Sabara and I think the defense and the lower court took what I would say a leap of rationality here, where they take the fact that our client understood these warnings to mean that he was actually aware of the risks. The problem here is that the defense, and we would suggest the lower court, never asked what he understood those warnings to mean. Because when you asked him what he understood those warnings to mean, he understood them to mean that it was sharp edges only. Now, Your Honor asked, did the safety bulletin talk about sharp edges? And I mistakenly said that it did not, but in actuality, when you read that bulletin, it does say that warnings do not have to be razor sharp. And I think when you put that into context with the warning tag that says avoid sharp edges, with the operator's instructions that it says avoid sharp edges, it's very reasonable, and all inferences should be drawn to the non-moving party that sharp edges were the ones to be avoided. That's historically what Mr. Mackey testified to, that users had been under this misimpression, and that's why the North Carolina OSHA inspector had the same misimpression, and the defendant's sales agent, Mr. West, had the same misimpression, that it was only sharp edges that had to be avoided. I see I'm over my time.
Do you have any case, contributory negligence in Virginia is a pure contributory negligence state too, so I'm used to how it works. But are you saying, do you have any case that says, this is hypothetical, really counterfactual, really, since if you've been doing something a certain way 1,000 times over 10 years, it's tried and proven to be works, but somewhere in there, in a manual, it says you're supposed to use an over-looping hitch rather than a closed knot.
Yeah.
And then it falls, and then you say, wait a minute, I understood because I've been doing this for 10 years and I always do it that way. Are you saying that you can avoid contributory negligence because of that usage and experience, notwithstanding that somewhere in a manual somewhere it says you should have tied it this way?
So,
do you have any case like that? Because I think it's kind of intriguing. That's kind of what this case kind of comes down to.
yeah, I think, first of all, the trial court never reached the issue of contributory negligence, and we certainly don't think there can be contributory negligence where everyone else had the exact same understanding as the plaintiff in this matter. Mm-hmm. But to the court's question, I do not have a specific case on the same grounds as the court would suggest. What we would suggest to the court is that Fontenot case is very similar, where all parties were under the impression that being hit with a taser in the chest could not cause cardiac implications. And that was the understanding in the industry for years. That is what Taser had advised users for years, until Taser learned shortly before the incident, the unfortunate incident, that cardiac implications could occur. And we have the same situation in this matter. The industry was unaware that any cut or edge, or pardon me, any corner or edge could cut these slings until Mr. Mackey's article in 2009 began the conversation and began other manufacturers updating their warnings and providing training to companies so that pitfall could be avoided, except for Certex. What Mr. Mackey's opinions and his report show is that Certex was behind the industry, didn't pay attention to industry warnings and standards, took no efforts to keep apprised of his developments and the industry's actions in this regard. And so all of the industry knew, and should have known, by Mr. Mackey's article and by the developments within the WSTDA, that it was something more than sharp edges that could cut these slings. But Certex didn't take any measures to educate and to warn their users and customers.
Except putting it on the sling itself.
Well, again, they did put it on the sling itself for a brief period that we believe should not be read in isolation, but should be used or interpreted in the context of the remaining warnings. Thank you.
Your expert did say it wouldn't have made any difference how you actually padded the edges, correct?
That's correct, and that's because you have to educate and warn users on the specific types of cut protection to
No, I'm not talking about warning, I'm talking about causation now.
Right.
He said that it didn't matter in terms of causation, however you, I guess, covered or matted protected the edges, be it sharp or otherwise, because of the actual rigging itself was the problem, is that right? Your expert, just tell me your expert.
Yeah, with regard to our expert, he doesn't say the rigging is a problem. He does say that the cut would have occurred even if the sling had been protected. So it would have cut right through that cut protection. If you put a blanket on it, if you would have put industry certified cut protection, it would have cut right through that cut protection as well.
Just because of the weight?
Because of the weight and because of the manner in which it was, generally because of the weight, yes.
The weight.
Thank you, Your Honors.
Thank you. All right. Counsel, both of you, thank you so much for your arguments and helping the court on these cases, and we appreciate it very much. Thank you. We'll proceed to our final case for the morning.
Oh, gosh, I didn't put this.
Ms. Patel?
Thank you, Your Honors. Good morning. In this case, at issue is whether this court should grant Mr. Graham's motion to authorize a successive 2255 motion challenging his Section 924C conviction based on Davis versus United States. And I'm happy to say that the parties agree that the court should do so here, because as this court already held in In re Thomas, Davis is a new rule of constitutional law that the Supreme Court has made retroactive and was previously unavailable. Your Honor, therefore, the gatekeeping requirements of 2255H are satisfied. And Section 2244B1 does not bar relief for Mr. Graham.
You say this is something you all agree on?
Yes, Your Honor, we both agree on every point.
Who are you
here.
arguing against?
I'm arguing against the United States government.
Say they agree with
Yes, they agree with us.
you, okay?
But this was set for oral argument, so that's why I'm,
I understand that, but I'm just saying, they agree with you. So what are you arguing? You about to tell us some reason that would give us a reason not to accept that agreement?
no, Your Honor, well,
Keep talking, you're gonna get some questions you're gonna find out. But I mean, I'm just saying, if you tell me they agree,
yes.
they get up and say I agree, what are you arguing?
Well, but
The only
Your
thing
Honor,
I
I mean,
can see can happen if you keep talking, you're gonna get some questions, and then all of a sudden, it may start taking a different direction. I'm just saying, it may not, but you proceed as you wish, but you just said they agree.
yes, Your Honor, and if the court does not have any
They looked at
questions,
you and said, yes, we do. What are you arguing?
I think you're correct, Your Honor. So if the court doesn't have any questions, then I'm happy to sit
I'm
down.
just trying to understand it, that's all.
Well, I mean, I was called to do the argument, so I just thought I would
But you
proceed.
just gave the argument. You said, they agree with us.
Right.
Why is that not an argument? Why you got to say anything more?
I
Unless
don't
the
have
court
to say
doesn't agree
anything
with you.
more, Your Honor.
The court may not agree with you. There's a problem there, but
Right.
just because you agree with them doesn't mean the court would. So, but if that's where you are, I don't know what you arguing.
Does the court have any questions, Your Honor?
I have a question for you.
Yes, Your Honor.
My question is this. You said that they agree with you, the government agrees with you. They agree with you that 2244B1 does not apply to successive 2255, right?
Yes, Your Honor.
They agree with that totally.
Yes.
Okay, that's the only question I have.
Okay, thank you, Your Honor. If the court doesn't have any further questions, then I'm happy to rest. Thank you.
All right, okay, great, thank you. Government, tissue?
Like you got a question to answer right off the bat, there, don't you? Do you agree with what was just said?
Thank you, Your Honor, and I'm Jonathan Suey on behalf of the United States. May it please the court. Both the appellant and the government agree that Section 2244B1 does not, of its own force, impose an additional hurdle to filing a second or successive 2255 motion. And that is because by its own terms, 2244B1 is limited to claims in a second or successive habeas corpus application under Section 2254.
Where do you disagree?
I don't believe the parties have a disagreement here, Your Honor, and I think Mr. Patel has
What do you know?
properly.
You just said y'all agree. I'm trying to understand what you're getting ready to tell us now. You want us to now do something more or what?
The government does not ask this court to do anything more. The government would rest on the parties' agreement if the court doesn't have any additional questions.
And you think the court's opinion ought to address what the points you agree on? You agree with that?
Your Honor, that would be sufficient, yes.
So the court's opinion should address the circuit split?
Your Honor, I think the government, there's a possibility that the court can avoid addressing the circuit split because we don't have the same claims being addressed here as were addressed in prior 2255 motions.
It's already a split. Well,
And the government also doesn't have any.
Why should the Fourth Circuit eschew a question that has already been resolved by several circuits, and it's not creating a split either way we go? And you both agree on, that's why I made a question was, did you agree on the fact that 2240B1 doesn't apply to 55, and you agree with that. So therefore, the court's decision ought to reflect that agreement, should it not?
I would agree with you, Your Honor,
Thank you.
yes,
That's
and I'm
all
not
I have.
asking the court to avoid that issue.
Right, that's all I have. Thank you. Anything else? All right, then, thank you, counsel, for appreciate your being here, and thank you, arguments and your
Thank you, Your
presentations.
Honor.
All right,